The meeting of the creditors, also known as the 341 meeting after the complaint. After filing a Chapter 7 bankruptcy, the court will issue a case number and a date for the meeting of the creditors, also called the 341 meeting. The bankruptcy filer must attend. This meeting is mandatory and should not be missed. Make sure you come to the meeting of the creditors with your Social Security card and government-issued identification. Most people get anxious about this meeting. They picture all their creditors inside the courtroom and that creditors are beating them with a long stick. But that is contrary to the truth. In fact, most creditors don't show up at all. If they do, they may ask 1 or 2 questions, if allowed. And the questions that are likely asked require simple answers. For example, let's say you have a debt outstanding on a vehicle. A creditor, likely a credit union, will ask if you are planning on keeping the vehicle. More time will be spent waiting for your turn in front of the trustee. The questioning may take 10 minutes if all the documents were provided to the trustee prior to the meeting of the creditors. The meeting of the creditors serves several purposes. It allows the bankruptcy trustee and creditors to review the debtor's bankruptcy petition, schedules, and statements, which detail their financial situation, assets, liabilities, income, and expenses. This review ensures that the information provided is accurate and complete. The debtor is required to answer questions under oath about their financial affairs and the details provided in their bankruptcy documents. This examination helps verify the accuracy of the information and ensures transparency in the bankruptcy process. Creditors are invited to attend the meeting, ask questions, and seek information about the bankruptcy case. They can also inquire about their prospects for repayment from the debtor's estate. Creditors may use this meeting to inquire about the debtor's assets, especially non-exempt property that might be sold to repay creditors. Sometimes, the meeting of creditors can help resolve disputes or issues that may arise during the bankruptcy process. Creditors may voice concerns or objections, and the trustee may seek clarification or propose solutions. The meeting serves to confirm the debtor's identity to prevent fraudulent filings. For some debtors, the meeting serves as an educational opportunity, where they can learn more about the bankruptcy process and their obligations. Commonly asked questions. 1. Did you sign the petition, schedules, statements, and related documents? 2. Did you read the petition, schedules, statements, and related documents before you signed them? 3. Are you personally familiar with the information contained in the petition, schedules, statements, and related documents? 4. Is the information contained in the petition and all accompanying documents true and correct? Are there any errors or omissions that you are aware of at this time? 5. Have you identified all of your assets on the schedules? Assets include anything of value, including accounts of all kinds, real property no matter if it is located out of the country, or personal property including even clothes and wedding rings. 6. Have you listed all of your creditors on the schedules? Creditors include relatives and anyone to whom you owe money. 7. Have you previously filed for bankruptcy? Generally, bankruptcies older than 8 years for Chapter 7 and less for Chapter 13 are fine, but they still need to be disclosed to the bankruptcy court and trustee. 8. Is the copy of the tax return your attorney provided to my office before this meeting a true copy of the most recent tax return you filed? If you have filed a more recent tax return, be sure to give a copy to your attorney a week prior to the meeting, or bring a copy to the meeting if it is even more recent than that. 9. Do you have a domestic support obligation such as child support or alimony that you owe another? To whom? You will be asked to fill out a form to provide the claimant's address and telephone number, but do not state it on the record for privacy reasons. 10. You will be asked if you are current on your post-petition domestic support obligations. 11. Have you filed all the required tax returns for the past 4 years? If you have not, you likely are not going to be eligible for bankruptcy relief unless you can get these done and quickly filed before a motion to dismiss is filed. 12. If you are expecting a tax refund for the year prior to filing your bankruptcy, you will need to send the refund check to the trustee. Do not direct deposit. And the trustee will do a calculation after the meeting to pro-rate the amounts over the 365 days of the preceding year. The trustee will return a portion to you representing any exemptions claimed and for the time period after you file bankruptcy. 13. Did you review the bankruptcy information sheet? This was provided to you when you hired us and explains the various types of bankruptcies. 14. Have you repaid any debts to family or friends in the last year? 15. What is the reason for your bankruptcy filing? 16. How did you arrive at the values you listed for your personal property on your schedules? 17. Are you paid by the hour or salary? What is your hourly rate, salary? 18. Identify any ownership interest and mortgages for real estate, even out of the country. All of this should be listed on your petition also. 19. Any transfers, giving or selling, anything to relatives or insiders in the past 2 years. 20. Anyone holding any property for you? 21. Have a claim against anyone else such as a slip and fall, car accident, someone owing you money, etc.? 22. Entitled to life insurance proceeds or an inheritance upon someone's death? 23. Are you a beneficiary or trustee of a trust? 24. Do you own a business? You can do this. Just be patient and prepared. Make sure your schedules are right. If you made a mistake, correct it. Thank you.